The Accomack County Sheriff's deputy in a brown uniform pulled into the gravel turnaround at the gate of my great-uncle Caswell Holloway's 560-acre Eastern Shore Peninsula at 11:14 a.m. on a Thursday in mid-October, with a Bayside Landing Estates HOA president named Gretchen Vance Waverly in the passenger seat in a turquoise quilted vest, a printed photograph of the no trespassing sign I had bolted to the gate at 7:47 that morning in her right hand, and a printed Bayside Landing community trail map in her left hand, showing 6 walking paths she said had been used by HOA members for 30 years. The deputy got out. She got out. They walked up to the gate. She said, before the deputy could speak,
"Officer, this sign is blocking community access pathways our OA has used since 1995. Mr. Holloway is interfering with our community, long-yanking use of these trails.
We want the sign down, and we want a formal trespass injunction against him for blocking the trails."
The deputy looked at the sign. He looked at me. I unzipped my canvas portfolio. I pulled out 2 documents. One was the 1814 federal land patent in my great-grandfather's name. The other was a 1972 conservation easement, recorded with the Accomack County Clerk in Book 188, page 47, held by the Nature Conservancy, covering the full original 800 acres of Holloway Peninsula in perpetuity. The deputy read both documents. He looked at Mrs. Vance Waverly. He said, "Ma'am, you need to step away from the gate. There is no such thing as a community access pathway across federally restricted conservation easement land. We need to talk in the cruiser." I came to the Holloway Peninsula on the Virginia Eastern Shore in October of 2024, 6 months after the death of my great-uncle Caswell Holloway, who had been 94 years old, who had been the 3rd-generation operator of the Holloway family land in Accomack County, Virginia, and who had been the last living Holloway to remember in detail what my grandfather Whitcomb Holloway had done in May of 1972, when he had signed the conservation easement that turned every acre of our family's 847 recorded peninsular acres into permanent open space. I am Benjamin Holloway, 64 years old, born in Norfolk, Virginia in March of 1960, to a U.S. Navy oceanographer and a high school biology teacher. I spent 36 years at the National Oceanic and Atmospheric Administration's Chesapeake Bay office in Annapolis, Maryland, the last 17 as the senior estuarine ecologist for the Chesapeake Bay program. My specialty was the tidal marsh ecosystems of the Atlantic coastal plain, with a particular focus on the salt marsh peninsulas of the Virginia Eastern Shore that lie between the Chesapeake Bay on the bay side and the Atlantic Ocean barrier islands on the seaside. I have published 41 peer-reviewed papers on Eastern Shore tidal estuaries. I have personally walked every salt marsh creek on the Holloway Peninsula in every year of my career, beginning when I was a 14-year-old summer field assistant to my great-uncle Caswell in 1974. Faye Marigold Holloway had been born in Onehancock, Virginia, in October of 1960, the daughter of a Wachapreague waterman and a public school librarian. We had met at a Hampton Roads Audubon Society meeting in 1984, when she was a brand new nurse at Norfolk General, and I was a first-year NOAA researcher. She had brought a casserole dish of crab quiche to the Audubon potluck. I had brought a half-finished paper on Pungateague Creek tidal marsh species inventory. She had asked me, in front of 41 Audubon members, whether anybody had ever explained to me how to talk to a woman at a party. I had said no. She had said, "Then I will explain it to you over the next 6 months." 6 months later, in April of 1985, I asked her to marry me on the Wachapreague waterfront at sunset on the 2nd Saturday of the month. She said yes on the 1st Saturday of May. I retired from NOAA in March of 2023. 15 months after my wife, Faye Marigold Holloway, died of a sudden cardiac event on the kitchen floor of our small Norfolk house on a Tuesday morning in January of 2022. Faye had been a registered nurse at Centera Norfolk General Hospital for 34 years. She had been 61. We had been married for 37 years. She had taught me, in the first year of our marriage in 1985, how to fillet a flounder without breaking the skin, how to read a tide chart, and how to apologize to a person without admitting fault. 3 skills that, in her own assessment, were the basis of a long and successful marriage on the Virginia Eastern Shore. Faye had given me 12 months at Norfolk General to be her primary caregiver, as her cardiac condition was diagnosed and then quietly worsened across 2021. We had been planning in those 12 months to move to the Holloway Peninsula in the spring of 2023 to spend our retirement years on Caswell's porch. Faye had picked out 2 rocking chairs at a Williamsburg craft fair in October of 2021. Bird's eye maple, hand-rubbed walnut finish, the kind of chair an Eastern Shore woman selects when she intends to outlive her husband by 20 years. The 2 rocking chairs are on the porch of Caswell's farmhouse. I sit in the left one. I leave the right one empty. Our daughter Theodora is 32, a marine ecologist at the Virginia Institute of Marine Science in Gloucester Point, married to a Virginia Marine Resources Commission staff attorney named Holden. They live in a small house in Hayes, Virginia. Our son Linus is 29, the licensed captain and sole owner of a charter fishing boat called the Faye Marigold, operating out of Wacapreague Harbor on the Atlantic side of the Eastern Shore. He lives in a single-wide trailer at the corner of Wacapreague Road and Seaside Drive, with a yellow Labrador retriever named Tide. My great-grandfather Asa Holloway purchased the original 847 peninsular acres from the federal government in May of 1814 under a Virginia land patent signed in Washington by Secretary of State James Monroe. The patent number was VA-LP-1814-0428. The land had been the federal share of a confiscated Loyalist estate from the Revolutionary War, sold by the Federal Land Office to clear inventory. Asa had paid $420 in silver coin for what is, in modern terms, a peninsula extending 3.5 miles southeast into the Chesapeake Bay, between Pungateague Creek and the unnamed tidal cut that the U.S. Coast Survey would later name Holloway Cove on its 1853 navigation map. My grandfather Whitcomb Holloway was born on the peninsula in 1898. He took over the farm in 1928 at the age of 30, when my great-grandfather Asa's son, my great-uncle Vance, died of influenza. He operated the peninsula as a working farm and oyster lease until his death in 1981. He was, in the small Eastern Shore farming community that surrounded Wachapreague in the 1950s and 1960s, the man who watched, with quiet alarm, the gradual conversion of every working peninsula on the Eastern Shore, from oyster and clam farming into vacation home subdivision development. In May of 1972, my grandfather Whitcomb Holloway signed a perpetual conservation easement with the Nature Conservancy of Virginia, donating the development rights to the full 847 acres of the Holloway Peninsula in perpetuity to the Conservancy, in exchange for a $1 payment and the satisfaction of knowing the peninsula would never become Bayside Landing Estates. The easement was drafted by a Norfolk Land Trust attorney named Calliope Vereen, who had been the founding general counsel of the Nature Conservancy of Virginia from 1970 to 1996. The easement was recorded with the Accomack County Clerk on May 14, 1972, in Book 188, page 47. The easement document was 41 pages long. It explicitly named, in paragraph 11 on page 7, the full metes and bounds description of the 847 acres. It explicitly prohibited, in paragraph 14 on page 9, any residential subdivision, commercial development, road construction, structural development other than maintenance of existing agricultural improvements, or any other use inconsistent with the perpetual preservation of the property in its current condition. The easement ran with the land. The easement was binding on all future owners and assigns. The easement was, by the language of Virginia Conservation Easement Law as written and ratified by the Virginia General Assembly in 1988, perpetual and enforceable in any future transfer of any portion of the property, regardless of disclosure. My grandfather Whitcomb died in 1981. His son, my great-uncle Caswell Holloway, inherited the peninsula. Caswell, who was 60 at the time, had been a high school agriculture teacher on Hancock for 34 years and had been planning to retire to the peninsula. He moved to the farmhouse in 1982. He continued the small working farm and the oyster lease until his death in early 2024. In April of 1985, Caswell Holloway, against the explicit recorded conservation easement and at the urging of a Norfolk real estate broker who had promised him a price he could not refuse for 240 acres at the southern end of the peninsula, sold the southern 240 acres to a Newport News developer named Bernard Camden for $1,100,000 in cash. The deed of sale was recorded with the Accomack County Clerk on April 22, 1985. The deed did not reference the 1972 conservation easement. Neither did the title insurance commitment Bernard Camden's attorney filed at closing. Neither did the warranty deed Caswell Holloway signed at the title company's office in Onekancock on the afternoon of April 22, 1985. The title insurance policy, by the standard exclusion language of all Virginia title insurance policies, did not cover defects of record that the title examiner should have discovered. The 1972 conservation easement was a defect of record. The title examiner should have discovered it. The title examiner had not, on the morning of April 22, 1985, pulled the May 1972 entries from Book 188. Bernard Camden subdivided the 240 acres into 64 lots between 1986 and 1995. He marketed the lots as the Bayside Landing Estates Planned Community, starting in 1995. The first home was built in May of 1996. The last lot was sold in March of 1999. Bernard Camden's development company, Camden Coastal Properties, LLC, filed for Chapter 7 bankruptcy in October of 2003. Bernard Camden died of liver cancer in 2009. His title insurance underwriter, a company called Tidewater Title Indemnity, had been absorbed by a larger national carrier in 2001 that had absorbed Tidewater's policies, but had not, in any year since, conducted a re-audit of Tidewater's 1985 closings. The Bayside Landing Estates Homeowners Association was formed by the residents in 2001 after Bernard Camden's bankruptcy. The HOA had governed the subdivision ever since. The HOA had, for 23 years, operated under the assumption that its 64 households held clear residential title to land that, by recorded conservation easement of May 14, 1972, could not legally be developed. None of the 64 households knew. Caswell Holloway had known. He had carried the knowledge for 39 years. He had not, by his own quiet decision, told his next-door neighbors. He had not told the Nature Conservancy of Virginia, which would have moved to enforce the easement at any point in those 39 years if it had known the development existed. He had not told any subsequent attorney, any subsequent insurance carrier, any subsequent county official. The 1985 sale to Bernard Camden had been the great regret of Caswell Holloway's long life, and the silence afterward had been the great cowardice. I learned all of this on the third Tuesday of October of 2024, 20 days after I moved into the farmhouse on the remaining 560 acres of the Holloway Peninsula, when I sat in the parlor of Caswell's old farmhouse with a 4-inch banker's box of papers his own Cancock attorney had left for me to inherit, and I read, in order, every document my great-uncle had kept on the peninsula since 1981. The banker's box was the cardboard banker's box my great-grandfather Asa had used to file the original 1814 land patent in. Caswell had kept the same box at the bottom of the parlor cabinet for 43 years. He had not, at any point in those 43 years, allowed me to look through it. Every summer I had visited him, beginning when I was 14 years old in 1974, he had pulled out individual documents from the box when he wanted to teach me a thing about the peninsula. He had never let me sit on the parlor floor with the box itself open. I had not, until October 14th of 2024, understood why. The box had been organized in approximate chronological order, top to bottom. The top sheaf was a manila folder labeled Caswell's Will, Draft, 2019, which contained the draft of the will my great-uncle had written by hand in pencil on a yellow legal pad on his 91st birthday in February of 2019, and which his attorney had typed and notarized in March. The will left the peninsula to me. The will did not mention the 1985 sale. The will did not mention the easement. Below the will was a manila folder labeled 1981 Estate Transfer, Whitcomb to Caswell. Below that was a manila folder labeled Oyster Lease, 1983, Renewal. Below that was a manila folder labeled 1985, Land Sale, Camden. Below that, finally, was a sealed cream envelope with my name on the front in Caswell's old man handwriting and the words, "To be opened first," printed in capital block letters beneath. I had ignored the "to be opened first" instruction for 19 days because the contents of any unsealed Caswell envelope were the kind of thing I had been mentally postponing since the day of his funeral. I opened the envelope on the night of the third Tuesday in October at 8:42 p.m. I read the handwritten letter inside. The letter is the one I have already quoted from. It was 3 pages long. The first page was Caswell's apology to me. The second page was Caswell's full account of the 1985 sale to Bernard Camden, including his admission that he had known about the easement and had chosen, against his father Whitcomb's recorded wishes, to sell the southern acres anyway because he had been 60 years old and had needed the money to fund his planned retirement. And because Bernard Camden's offer of $1.1 million in 1985 had been more cash than he had ever seen in his life. The third page was Caswell's instruction to me for what to do. The instruction was specific. It listed the Nature Conservancy of Virginia. It listed Constance Brewer's name. It said Constance had been a conservancy intern in 1989, when Caswell had quietly invited her down to the peninsula for a single tour, on which Caswell had walked her around the perimeter of the 1985 sale and had said to her, in his Eastern Shore voice, "Constance, someday a young Holloway will call you about this peninsula. When that day comes, please be patient with him." Constance had been 23 years old in 1989. She was 58 in 2024. The bottom document in the box was a handwritten letter from Caswell to me, dated December 14th of 2023. Written 6 weeks before he died, that began with the sentence, "Benjamin, you will find this box at the bottom of the parlor cabinet after I am gone. I have not been able to bring myself to fix what I did in 1985. The Nature Conservancy must be notified. The Bayside Landing families must be helped to relocate. The peninsula must be restored. I am very sorry I left this to you. Your grandfather Whitcomb would have done it himself." I read the letter at the parlor table at 8:47 p.m. on a Tuesday in late October. I read it 3 times. I called Theodora at home in Hayes. I read her the letter over the phone. She did not say anything for a long minute. Then she said, "Daddy, you need to call the Conservancy first thing tomorrow morning." I called the Conservancy at 7:14 a.m. on Wednesday, October 23rd, from the parlor table. The Director of Land Protection for the Nature Conservancy of Virginia, a woman named Constance Brewer, who had been with the Conservancy since 1998, answered her direct line on the third ring. I told her, in the careful, estuarine biologist voice I had been using at the NOAA Chesapeake Bay office for 17 years, that the family had a 1972 conservation easement on file with the Accomack County Clerk in Book 188, page 47, and that there appeared to be a 64-home residential subdivision built in violation of the easement on the southern third of the property. Constance Brewer was quiet for a moment. Then she said, "Dr. Holloway, the Holloway easement is in our active enforcement file. We have had a flag on it since 2001, when our records department first cross-referenced the original 1972 grant against the 1985 deed of sale. We have been waiting for a cooperating landowner, meaning a member of the Holloway family, to provide standing for federal court enforcement. We have been waiting since 2001. I said, "Mrs. Brewer, I am the cooperating landowner. The peninsula is mine." She said, "Dr. Holloway, may I drive up to Wachapreague tomorrow afternoon and meet with you in person?" She drove up Thursday afternoon. She arrived at the farmhouse at 1:14 p.m. with a printed copy of the easement, a printed copy of the 1985 deed, a printed copy of the Bayside Landing Estates platting documents, a tablet showing the GIS overlay of the easement boundary on the current subdivision footprint, and a leather portfolio that contained a draft federal complaint for emergency injunctive relief under the Internal Revenue Code 170H, charitable deduction enforcement provisions, the Virginia Open Space Land Act, and Virginia Code Section 10.1-1009, Conservation Easement Statutes. The draft federal complaint was already 11 pages long. It had been sitting in Constance Brewer's enforcement file since 2003. She said, "Dr. Holloway, once you authorize the Conservancy to proceed, we can file in the U.S. District Court for the Eastern District of Virginia within 48 hours. The injunction will issue within hours of filing. The HOA will be enjoined from all further activities on the property pending federal court resolution. The HOA's residential title insurance carriers will be notified by federal court order. The HOA's insurance policies will, by standard policy language, be reviewed for material non-disclosure. The HOA will, by my estimate, lose its operating insurance within 72 hours of filing. The HOA's board members will face personal liability exposure within 96 hours. The HOA will collapse as a functional governance entity within 1 week." Constance also showed me on her tablet the GIS overlay of the easement boundary on the current Bayside Landing subdivision footprint. The 64 lots covered approximately 140 acres of the easement parcel. The remaining 100 acres of the easement parcel, inside the original 240-acre sale tract, were undeveloped HOA common area, salt marsh edge, bayfront pine forest, and a small freshwater pond Bernard Camden had dug in 1996 as a community amenity. The bayside fronts of 14 lots had been partially graded and bulkheaded in 1995 to 1998 in violation of Virginia's tidal shoreline stabilization permits, separate violations that would, by the federal complaint, be folded into the umbrella settlement. I said, "Mrs. Brewer, I authorize the Conservancy to proceed." I signed the authorization on her tablet at 1:47 p.m. that Thursday afternoon, at the parlor table of my great-uncle Caswell's farmhouse, looking out the window at a pair of ospreys hunting over the Holloway Cove salt marsh at low tide. Constance Brewer stood up. She walked to the parlor window. She looked at the ospreys for a long minute. Then she turned around and said, in the careful Conservancy attorney's voice she had been using on Virginia landowners since 1998, "Dr. Holloway, I have one personal question before I drive back to Charlottesville this afternoon. May I ask it?" I said, "Of course." She said, "Your great-uncle Caswell drove me around the perimeter of this property on a Sunday afternoon in October of 1989. I had been on the job for 2 months. I was 23 years old. I had grown up in Suffolk, Virginia, and had not, at that point, ever set foot on the Eastern Shore. Your great-uncle had requested that the Conservancy send a junior staff member to walk the property with him because, in his exact words on the phone to my supervisor, "I have made a mistake, and I want a young person to know about it so a future Holloway can find me again." I walked the perimeter with him for 4 hours. He told me about the 1985 sale. He told me about Bernard Camden. He told me, by name, that there would someday be a young Holloway coming back to the peninsula. I have, since the day I made Director of Land Protection in 2014, checked the Conservancy's incoming call log every Monday morning for the name Holloway. I have been checking for 10 years and 1 month. You are the call I have been waiting for. I did not say anything for a long minute. I said, "Mrs. Brewer, my great-uncle was 60 in 1989. He was 94 when he died. He never told me. He never told my father. He never told anybody in the family. He told you." She said, "Dr. Holloway, he told a stranger because he could not tell his own family. That was the cowardice. That is also the act that gave us the federal complaint we are about to file. Your great-uncle saved this peninsula. He just needed the next generation of his family to be the one to sign the authorization. You signed it. The peninsula is safe." I sat at the parlor table for a long minute. I said, "Mrs. Brewer, drive safe." She said, "Dr. Holloway, I will see you Monday morning at the federal courthouse in Norfolk." Linus came up to the farmhouse from Wachapreague at 4:47 p.m. on Thursday afternoon, 3 hours after Constance Brewer had left to drive back to Charlottesville. Linus brought a 5-gallon bucket of unshucked oysters from his Wednesday harvest at the Eastern Shore Oyster Cooperative grounds off Cedar Island, a half-gallon of buttermilk from the small Bayside dairy at Pungateague, and a thermos of his late mother's clam chowder he had reheated on the boat that afternoon. He set the bucket on the back porch step. He sat down at the parlor table with me. He read Caswell's December 2023 letter for the first time. He did not speak for 14 minutes. When he spoke, he said, "Daddy, Great-Uncle Caswell took 39 years to write that letter. He left it for you because he could not give it to anybody else. I am very proud of him for writing it." I said, "Linus, so am I." He said, "Daddy, the peninsula stays in the family. The amended easement stays in place. The bronze plaque the Pelhams will install next May for great-grandfather Whitcomb stays at the corner of Bayside Drive and Holloway Vista Lane forever. The Conservancy continues. The Ospreys continue. The Salt Marsh continues. The peninsula will be exactly the peninsula great-great-grandfather Asa bought from James Monroe in 1814 for $420 when my grandchildren are out here in 2074. I said, "Linus, that's the plan." He said, "Daddy, I would like to bring Tide up tomorrow morning for the cop visit if there is one." I said, "Linus, bring Tide." Linus and Tide were on the front porch at 7:14 a.m. Friday morning with a fresh thermos of clam chowder and a folding chair when I bolted the "No Trespassing" sign to the front gate. They were still on the front porch at 11:14 a.m. when Deputy Castro and Mrs. Vance Waverly arrived. I called Theodora at home in Hayes on Thursday evening at 9:14 p.m. and read her the federal complaint Constance had filed at the federal courthouse in Norfolk. Theodora read it through with me on speakerphone over the next 41 minutes. She had been a Vims Marine ecologist for 6 years. She knew the Eastern Shore Land Trust framework as well as her father did. By the end of the call, she had identified 2 technical issues in the GIS overlay: a miner's surveyor's coordinate offset of approximately 0.4 meters that the Conservancy team would correct on Friday morning, and 1 substantive procedural concern. The federal complaint should also cite the Virginia Open Space Land Act, which Constance's team had not included in the first draft. Theodora emailed her notes to Constance at 11:08 p.m. Constance emailed back at 11:14 p.m. with a single line that read, "Dr. Theodora Holloway, join the complaint as co-plaintiff. Confirmed, 11:14 p.m. Theodora was added as a co-plaintiff before sunrise, Friday morning. She drove up to the Holloway Peninsula on Friday afternoon at 2:14 p.m. after teaching her morning graduate seminar in Gloucester Point. She arrived at the farmhouse at 4:18 p.m., 29 minutes before Judge Soto Hernandez signed the emergency TRO in Norfolk. The next morning, Friday, October 25th, I drove to the True Value hardware store in Onecancock at 6:30 a.m. and bought a large weatherproof aluminum "No Trespassing" sign, 4 heavy-duty galvanized lag bolts, and a small can of black exterior paint. I drove back to the peninsula. I painted, on the bottom of the sign in careful capital block letters with a small brush I had brought from the workbench in Caswell's barn, the additional line, "Protected Conservation Easement." Book 188, page 47, The Nature Conservancy of Virginia. I bolted the sign to the main farm gate at 7:47 a.m. By 9:14 a.m., 2 Bayside Landing Estates residents on their morning walks had photographed the sign. By 10:31 a.m., the photographs had been forwarded to Gretchen Vance Waverly, the HOA president, on the Bayside Landing Community Facebook group. By 10:48 a.m., Gretchen had called the Accomack County Sheriff's Office to file a complaint that I was interfering with long-standing community trail access, and that my sign was intimidating community members. The deputy was at my gate by 11:14 a.m. I have already told you what happened in the first 3 minutes after the deputy and Gretchen arrived at my gate. What happened in the next 30 minutes was that the deputy, Brendan Castro, age 29, 4 years on the job at the Accomack County Sheriff's Office, read both the 1814 federal land patent and the 1972 conservation easement at the gate, photographed both documents on his department phone, walked Mrs. Vance Waverly back to the cruiser, and informed her in language she did not entirely understand at the time that no community access pathway across recorded conservation easement land could legally exist, regardless of how many years it had been informally used. He drove her back to her own home at the corner of Bayside Drive and Holloway Vista Lane in Bayside Landing Estates. He filed the incident report at the Accomack County Sheriff's Office at 12:42 p.m. By 1:08 p.m., the report had been forwarded to the Virginia Department of Conservation and Recreation. By 2:14 p.m., the department had cross-referenced the report against the easement registry and confirmed the violation status of the entire Bayside Landing Estates development. The department's senior easement enforcement officer, a woman named Petra Montavani, who had been with the department since 2008, called Constance Brewer at 2:31 p.m. from her field office in Tappahannock. Petra had a copy of the 1972 easement and the 1985 deed of sale already open on her screen. Petra and Constance spoke for 14 minutes. By 2:48 p.m., the department had issued a formal regulatory finding that the Bayside Landing Estates development was non-conforming with the conservation easement of record, and that all 64 lots were subject to state and federal enforcement action. By 3:01 p.m., Petra Montavani had emailed me a courtesy copy of the regulatory finding at the email address Constance had given her. By 3:08 p.m., I had forwarded the finding to Theodora at VIMS and to Linus at his Wachapreague charter office. By 3:14 p.m., Theodora had called me back with one sentence. She said, "Daddy, Grandpa Whitcomb is winning." I did not say anything for a moment. I sat at the parlor table, looking at my great-grandfather Asa's 1814 land patent and my grandfather Whitcomb's 1972 conservation easement, spread side by side on the surface. The patent was on parchment. The easement was on white legal document bond. The two documents bracketed 158 years of Holloway family stewardship of the peninsula. The two documents had, between them, by 3:00 p.m. on Friday, October 25, 2024, just become the entirety of the case the Conservancy was about to win. I said, "Theodora, your Grandpa Whitcomb is winning. Your great-uncle Caswell is being forgiven. The peninsula is going home." Theodora was quiet for a long moment. She said, "Daddy, Mom would be on the porch right now in her right-hand rocking chair, watching the ospreys with you, and crying." I said, "Theodora, your mother is on the porch. I just can't see her." She did not say anything else. She did not need to. She hung up gently. I sat at the parlor table for a long minute. Then I walked outside to the front porch. I sat down in the left rocking chair. The right rocking chair was empty. The ospreys were still working the creek mouth at the head of Holloway Cove. The October light was the gold, late-afternoon eastern shore light my grandfather Whitcomb had painted in oils on the parlor wall in 1968. I did not say anything out loud. The peninsula said it for me. By 3:18 p.m. on Friday, October 25th, the Conservancy's draft federal complaint had been finalized by Constance Brewer's attorney team in Charlottesville and filed electronically with the U.S. District Court for the Eastern District of Virginia, Norfolk Division. Judge Magdalena Soto Hernandez signed the emergency temporary restraining order at 4:47 p.m. that same Friday afternoon. The TRO enjoined the Bayside Landing Estates Homeowners Association and its 64-member households from any further development, modification, expansion, construction, or commercial use of the southern 240 acres of the Holloway Peninsula, pending federal court resolution of the underlying easement enforcement action. The TRO was served on Gretchen Vance Waverly at the Bayside Landing Estates Community Clubhouse at 6:14 p.m. on Friday by a U.S. Marshal who had driven up from Norfolk with the order in a sealed envelope. The HOA had, by complete coincidence, an emergency board meeting already scheduled for 6:30 p.m. that Friday. Gretchen had called the meeting at 12:14 p.m. to discuss my no trespassing sign and to propose a coordinated HOA legal response. The meeting was, by 6:48 p.m., a different kind of meeting. The U.S. Marshal stayed for the meeting. Constance Brewer drove down from Charlottesville and arrived at 7:11 p.m. with 2 associate attorneys and a printed binder for every board member. The Conservancy attorney team walked the 7 HOA board members through the 1972 easement, the 1985 illegal sale, the conservation easement enforcement framework, the immediate effect of the TRO, the projected federal court timeline, a permanent injunction within 90 days, no realistic legal defense given the recorded easement, the insurance implications. Every HOA member's title insurance carrier would be required by the TRO to review the policies for material non-disclosure within 72 hours. and the proposed Conservancy Settlement Framework. The proposed Conservancy Settlement Framework was, given the impossibility of relocating 64 occupied homes, a negotiated amended easement that would permit the existing residential improvements to remain, under restrictive terms, in exchange for a $3 million payment from the HOA Reserve Fund and from individual homeowner contributions to a Holloway Peninsula Restoration Trust, to be administered by the Conservancy. A permanent prohibition on any further development, expansion, or modification of any existing improvement beyond like-for-like maintenance. A permanent prohibition on the construction of any new residential structures, commercial structures, recreational structures, fences other than agricultural, lighting other than residential porch lighting, septic systems other than those existing, or wells other than those existing. A permanent restoration of the 4 salt marsh edge buffers that Bernard Camden's 1995 to 1998 grading had filled or modified at HOA expense. A permanent transfer of all undeveloped HOA common area land, approximately 41 acres, to the Conservancy. A permanent recall of Gretchen Vance Waverly from any officer position at Bayside Landing Estates or any other Virginia Homeowners Association. A public written apology from the Bayside Landing Estates HOA to the Holloway family and to the Nature Conservancy of Virginia for the 23 years of unauthorized use of conservation easement land. The 7 HOA board members, when they read the settlement framework on Constance's printed binders at the clubhouse table that Friday evening, did not look at each other for a long minute. Mrs. Vance Waverly did look around. She looked at the U.S. Marshal in his blue jacket and badge, standing at the back of the clubhouse. She looked at the 2 Conservancy Associate Attorneys at Constance's left and right. She looked at the printed federal court TRO, sitting on the green felt table in front of the board. She looked, finally, at Whitaker Pelham, the retired Annapolis ophthalmologist on her board, who had been her quietest critic for 2 years, and who had warned her, at 3 separate executive sessions in 2023 and 2024, that her dispute with the Holloway family was probably going to end badly. Whitaker Pelham did not look at Mrs. Vance Waverly. He looked at Constance Brewer. He said, "Mrs. Brewer, on behalf of the Bayside Landing Estates Homeowners Association, I move to accept the proposed settlement framework, subject to membership ratification, at a special meeting to be called within 14 days. The second came from the HOA treasurer, a retired Virginia Beach orthodontist named Eustace Holcomb, before Whitaker had finished the sentence. The board voted 6-1. The HOA board, after 31 minutes of discussion in front of the Conservancy attorneys and the U.S. Marshal, voted 6-1, Gretchen abstaining, to accept the settlement framework, subject to membership ratification. The vote was taken at 7:48 p.m. on Friday, October 25, 2024, exactly 8 hours after Mrs. Vance Waverly had called the Accomack County Sheriff at 10:48 a.m. that morning to complain about my no trespassing sign. The Bayside Landing Estates Homeowners Association did not, in any meaningful operational sense, exist as the entity it had been at 10:48 a.m. that morning, by the close of business at 7:48 p.m. that evening. Mrs. Vance Waverly sat at the board table during the entire vote and did not raise her hand for either side. At the moment the gavel came down at 7:48 p.m., she stood up. She did not say anything to the board, the Conservancy attorneys, or the U.S. Marshal. She walked across the clubhouse to the front double doors. She paused with her hand on the door handle for 9 seconds, looking at the empty November parking lot through the glass. She did not look at me. I had been sitting in the back row of the clubhouse since 6:55 p.m. at Constance's request, and she did not look at her own husband Brixton, who had come in at 7:14 to find out what was happening to his wife, and who was now sitting in the second row with his head in his hands. She opened the door. She walked out into the parking lot. She got into her white Cadillac Escalade. She drove home in the dark. Brixton Vance Waverly filed for divorce 4 weeks later, on November 21st, 2024. The divorce filing cited fraudulent inducement to marry, language his Richmond corporate law colleagues had drafted on his behalf, based on Gretchen's failure to disclose her involvement in the 2018 PSC dispute and her concealment of the federal litigation risk that she had been quietly aware of since 2022, when Caswell Holloway had first informally contacted her at the HOA office about the easement. Gretchen had, according to records subpoenaed during the divorce proceedings, listened to Caswell's quiet warning, dismissed him as a paranoid old man, and never raised the matter again with anyone. Gretchen Vance Waverly was formally recalled by emergency membership vote at a special meeting held at the community clubhouse on Saturday, October 26th at 2 p.m. The vote was 57-5. Whitaker Pelham, a retired Annapolis ophthalmologist who had been the lone dissenter at the Friday night board meeting. He had argued for accepting the settlement, but had voted no because he had wanted the Conservancy to take a smaller payment, was elected interim president. Whitaker's first official act on Sunday morning at 9 a.m. was to drive to my farmhouse with his wife Ileana and a hand-baked rhubarb crumble Ileana had made overnight, to apologize, on behalf of the community, for the 23 years of unauthorized use of my family's land. I accepted the apology. I accepted the rhubarb crumble. We sat on the porch for an hour and watched the ospreys hunt over Holloway Cove. Whitaker did not say much for the first 30 minutes. Then he said, "Dr. Holloway, I retired from medical practice in 2014. I have lived in this house since 1997. I have walked the trails on your property approximately 1,400 times. I am very sorry. I had no idea." I said, "Whitaker, nobody did. My great-uncle was the only person who knew. He could not bring himself to say it. I am the one saying it for him now." Whitaker said, "Dr. Holloway, may I ask one question?" I said, "Of course." He said, "Did your great-uncle ever forgive himself?" I thought about it for a long minute. I said, "Whitaker, I don't think he did. He left me a letter. The letter said he had been a coward. I believe he meant the word." Whitaker did not say anything for a long minute. Then he said, "Dr. Holloway, I would like to commission a small bronze plaque to be installed at the corner of Bayside Drive and Holloway Vista Lane, in memory of your grandfather Whitcomb, with a single line at the bottom. The line would say, 'In your great-uncle's name, forgiven.'" I said, "Whitaker, the plaque is approved. My great-uncle would have wept." The second special meeting on Saturday, November 9th, was held at the Bayside Landing Estates Community Clubhouse at 2 p.m., and ran for 2 hours and 41 minutes. 62 of the 64 households were represented in person or by proxy. Whitaker Pelham, as interim president, opened the meeting with a 30-minute briefing on the settlement framework that Constance Brewer had drafted in coordination with my Norfolk attorney across the previous 9 days. Constance herself attended the meeting in person and answered questions from the membership for 1 hour and 7 minutes. The questions were thoughtful, technical, and respectful. The membership did not vent. The membership did not assign blame. The membership had, by the time of the second meeting, read enough Conservancy documentation and enough Eastern Shore Land Trust history to have understood that the situation was the consequence of a 1985 transaction that had been made before any of them had moved into the subdivision, and that the path forward was the path Constance had drafted. The settlement framework was ratified by the Bayside Landing Estates membership at a second special meeting on Saturday, November 9th, by a vote of 59-3. The $3 million payment was wired to the Nature Conservancy on Friday, November 15th. The amended easement was recorded with the Accomack County Clerk on Monday, November 18th, in Book 488, page 217. Exactly 300 pages and 52 years after the original easement at Book 188, page 47. Gretchen Vance Waverly sued her husband's title insurance carrier in February of 2025 for non-disclosure of the easement at her 2008 home purchase and recovered $84,000 in a confidential settlement in May. She used the settlement to buy a smaller condominium in Virginia Beach, where she moved with her 2 adult daughters in June. She did not contest the recall. She did not return to Bayside Landing Estates after July of 2025. She has, by Whitaker's most recent report, settled into a quiet retirement on the Atlantic side of the Lower Bay, and is, in her own brief Christmas card to Whitaker, dated December of 2025, trying very hard to be a good neighbor in my new building. The Holloway Peninsula Restoration Trust was funded by the HOA's $3 million settlement payment on Friday, November 15, 2024. The trust was administered by the Nature Conservancy of Virginia under a stewardship agreement Constance Brewer drafted across the second week of November. The restoration scope included full regrading of the 4 salt marsh edge buffers Bernard Camden had altered in 1995 to 1998. Estimated cost $640,000. Removal of 41 non-conforming structures, fences, lighting fixtures, and septic improvements throughout the Bayside Landing footprint that exceeded the amended easement's like-for-like terms. Estimated cost $480,000. Transfer to Conservancy ownership of the 41 acres of HOA common area land along the bayfront and the salt marsh. No monetary value to the HOA, but significant to the trust. Funding of a permanent Conservancy stewardship endowment to monitor and enforce the amended easement in perpetuity, $1,100,000. And a one-time Holloway family legal fee reimbursement of $78,000 to cover my retained Norfolk attorney's time in the federal action. I converted my 560 acres of the Holloway Peninsula into a permanent stewardship partnership with the Nature Conservancy in March of 2025, with the original 1972 easement extended through 2017 by a formal extension instrument, and with Theodora and Linus named as the inheritors of the stewardship responsibility. The peninsula is open to the public on Saturday mornings from sunrise to sunset for guided walks led by Theodora's VIMS graduate students. The first guided walk was held on April 12, 2025. 41 people came. Linus brought oysters from the Wachapreague harbor. Ileana Pelham brought a rhubarb crumble. Whitaker Pelham brought himself. The Ospreys did not know there had been a problem. The amended easement was recorded with the Accomack County Clerk on November 18, 2024 at 4:11 p.m. The recording clerk, a woman named Bertie Hatch, who had been at the clerk's office since 1991 and who had known Caswell Holloway as a regular Tuesday morning visitor across all 33 years of her career, stamped Book 488, page 217, with the same brass-handled date stamp my great-uncle had stood beside at the counter on the morning of April 22, 1985, when the original Bernard Camden deed had been recorded. Bertie handed me the certified copy at 4:14 p.m. across the counter. She said, "Benjamin, I worked the morning your great-uncle recorded the Camden deed. I knew that morning he was making a mistake. I could not say so. I am very glad you are recording this one. Your great-uncle would be in the parking lot right now with tears in his eyes." I said, "Bertie, thank you for keeping his secret for 39 years. She said, "Benjamin, I never kept it. I just never had a Holloway to tell." Whitaker Pelham installed the bronze "Forgiven" plaque at the corner of Bayside Drive and Holloway Vista Lane on a Saturday morning in May of 2025. The plaque is the size of a small kitchen cutting board. It bears Whitcomb Holloway's name at the top, the dates 1898 to 1981, the dates of the original easement and the amended easement, and the single word "Forgiven" at the bottom. Ileana Pelham hosted the dedication potluck at her own house that afternoon. 41 of the 64 Bayside Landing households attended. Linus brought oysters from Wachapreague. Theodora brought a printout of a peer-reviewed paper she had just published on Pungateague Creek tidal marsh recovery, which she had dedicated to her great-great-grandfather, Asa Holloway. I brought myself and a thermos of coffee. The peninsula across the fence line looked exactly the way Caswell had wanted it to look. Theodora and Linus drive up most third weekends of the month. Theodora brings Holden and their 2-year-old daughter Marigold, named for Faye, who would have been the grandmother holding her on the porch swing every Sunday afternoon. Linus brings Tide and a thermos of clam chowder. We eat at the farmhouse kitchen table that my grandfather Whitcomb built out of seasoned pine boards in 1928. We watch the sun go down over Holloway Cove from the porch. Marigold, who is 26 months old as of this writing and has been learning her first words for 10 months, has begun saying "Osprey" with the careful concentration of a child who has been told the word by her marine ecologist mother and by her marine biologist grandfather more times than any other word she has heard in her short life. She says it pretty well. She also says, "Grandma Faye," in the careful 2-year-old voice she has been practicing for 4 months, when Theodora points at the second framed photograph on the parlor mantel, which is the photograph of Faye Marigold Holloway on the porch of our small Norfolk house on a Sunday afternoon in October of 2021, 3 months before she died, holding a freshly steamed Chesapeake Bay blue crab in her right hand and the cracker in her left, smiling the smile she had been smiling since I had met her at the Audubon potluck in 1984. I sit on the front porch of Caswell's farmhouse most evenings with a thermos of coffee. The peninsula is exactly the place it was in 1814. The 1972 easement, by extension, will keep it that place until 2017-40. By 2017-40, my great-great-grandchildren may be on a porch like this one, looking at ospreys their great-great-great-grandfather Whitcomb had ensured would have a place to hunt. If you have ever discovered, after inheriting a piece of family land, that your grandfather had quietly done a brave thing decades earlier that the rest of the world never knew about, comment below with your state and what he did. Read every one. Subscribe. Next week, a Florida widower, a 1972 Cadillac, and the HOA president who picked the wrong car. She picked the wrong Cadillac.
What Gretchen Spence Waverley did not understand, and what most petty tyrants never understand, is that the man on the other side of her HOA Spence lies was not a quiet retired federal scientist she could intimidate off inherited Eastern Shoreline. He was a 36 years NOAA veteran who has worked every source Mars Creek on the peninsula since he was 14, and his grandfather has quietly placed the entire 847 acres into a perpetual conservation easement with the Nature Conservancy on a Sunday afternoon in May of 1972. She thought a no trespassing sign was intimidating signage. He thought a recorded conservation easement was perpetual federal state law. The easement wins because a recorded conservation easement does not get angry and does not need to leave its voice. If your grandfather or great-uncle ever quietly placed family land into a conservation easement and forgot to tell you, the first thing you should do tonight is search for public recorder database for any easement recorded in your family's name. The document is almost always still there. The Nature Conservancy is almost always still holding it. If this story hit home, drop your own HOA nightmare in the comment, your state and what they try to walk across. Subscribe. Next week, a Florida widower, a 1972 Cadillac, and the HOA president who picked the wrong car. See you on the next one.